Hi, this is Jim Cunningham. We're going to talk about trust administration checklist for California. So a lot of people, they want to know, what do you do when somebody passes away or somebody stops being trustee? So you create this living trust, or maybe someone you know, maybe it's a loved one. They've created this trust, then they pass away. What do you do next? What is all the stuff that you have to do? And a little bit of a spoiler alert, it's not enough to simply follow the terms of the trust, and we'll see why. So trust administration in California, we use checklists. Pilots use checklists. And I am not a current pilot, but the reason pilots use checklists is because it's important stuff when you're flying a plane, right? And they say in aviation, if they don't say it's crashing your plane, it's saying having a bad day. So that's little pilot speak for something really bad happening. But the idea here is we use a checklist so we don't mess things up. But for you, the normal person, right? You may be overwhelmed by this. You may go, oh my goodness, this thing's 100 pages long. It's like, oh my goodness, what do I do? Someone's passed away. I've got people reaching out to me. I've got creditors calling. What do I do? Where do I even start? So we're going to help untangle some of the intricacies of trust administration and shed a little bit of light on this. If you're watching this on YouTube, we record these live. If you're watching this on YouTube, go ahead and subscribe to our YouTube channel and hit the little bell. Give us a little thumbs up. That'd be great. And then this will pop up in your feed. We release these about at 6 p.m. Pacific time every Thursday. So I'm Jim Cunningham, a partner at Cunningham Legal. We have offices throughout California. I am a certified specialist in estate planning, trust, and probate law, a real estate broker, securities, and insurance license. As I mentioned, not a current pilot, but a third generation pilot. So this is really important. When I say you, there's no attorney-client relationship attaching to this video. I'm saying you so that you can understand what I'm talking about, because this is not easy stuff. It's very dense. It's arcane. It's kind of difficult to wade through for most normal people, meaning not a lawyer. So there are lawyers and then there's normal people. And if you're not a lawyer, you're a normal person. But really, I think the bottom line here is don't watch this and go out and do a bunch of stuff or not do a bunch of stuff. And so what is trust administration? So this is a word, I really don't like it. You might hear this, trust administration. What does that even mean? It just sounds like a really generic doublespeak kind of term. But trust administration is a process, okay? So it has typically a beginning and an end that the trustee follows when, and I'll use the term grantor, maybe the creator of the trust, the person who sets the trust up. So if I set up a living trust and then I die, my successor trustee becomes the trustee and then goes through trust administration. But this typically occurs when the person, and we're talking here about a living trust, when someone sets up a living trust, when that person stops being trustee, typically because of death, many times incapacity. Please don't forget about incapacity, right? Sort of that twilight period between when you're a fully functioning adult and dead. Like there's this period that a lot of people go through where they really just don't have all their marbles and they need some help. So what are the basic steps? Number one, and we'll get into more steps, but I'm just giving you an orientation of what this is. Identification of trust property. You need to figure out what's in the trust, what's not in the trust, right? What should be in the trust that isn't in the trust. So identifying the trust property, all of the trust property, and then taking control and managing the trust property. So taking control means if it's Jim Cunningham as trustee of the Jim Cunningham Trust and Bob takes over as successor trustee, my name, Jim Cunningham, comes off the name and it's Bob, trustee of the Cunningham Trust, right? So my name comes off as trustee. The next trustee's name goes on. So you do that by going to financial institutions. You do that by recording documents at the county recorder. When we're talking about real estate, you might have to update an operating agreement if you have an LLC. You might have to update your bylaws or your corporate records if you have a corporation. So a lot of little nits, a lot of little details that you got to go through. But this is what I mean by taking control of, and then certainly managing trust property. And you manage that for the benefit of a beneficiary. Now, bene is Latin meaning goods or good. The beneficiary is the person who gets the goods. So as we're going to discuss here, trustees have duties, beneficiaries have rights. So beneficiary and baby start with the B. Beneficiaries are the babies. It's like an infant. They just sit around and they're eating and sleeping and doing whatever babies do. They don't have a lot of responsibility, right? That's what a beneficiary is. So the beneficiary is really in a passive role. The trustee is in the driver's seat, but the trustee has duties, and that money is not the trustee's money. Now, certainly a trustee could be a beneficiary as well, but understand that the trustee is in charge, but does not get the beneficial ownership or use of that trust property. So then we talk about distributing trust income and principal by successor trustee. There is a distinction between income and principal that we'll kind of touch on, but you can think of that as the trust assets. So in most states, and this is very important to understand, in most states, including California, if there's no trust, you're going to go through probate court. And in California, it's 4 to 8% more or less of the value of an estate. It can be 100%. So $1 million estate, let's say I die with a house that's worth $1 million and I don't have an estate plan. Full disclosure, I do have an estate plan. I do have a living trust centered estate plan. But if I didn't and I die and my house is worth $1 million, whoever serves as executor in the probate court, they're going to have to pay fees, right? The executor is going to be writing the checks out of the estate funds. And that can be, it's about $50,000 on $1 million in asset value. But remember, this is on the gross value of the asset without any factoring of debt. So if that $1 million house has a $950,000 mortgage, the probate fees are still $50,000. Hence, the probate fees can absorb or consume the entire estate. So not a similar situation with trust administration. Typically, we cover trust administration fees in a different webinar or different video on YouTube. So when somebody passes away or becomes incapacitated, there are a lot of different processes that you can go through, a lot of different documents that you'll be looking at. So we talk generally about trust administration. Ideally, you're staying out of probate court. Ideally, you're avoiding a conservatorship. It would be a guardianship in California if somebody's under the age of 18. But if they're 18 or over, that is a conservatorship is a court-run proceeding for typically someone who has no estate plan and lacks mental capacity to do stuff. If somebody has a living trust centered estate plan, but is non-compliant. What do I mean by non-compliant? You know, they're not acting like they should be acting, right? They can be what is called conserved. So even if you have a living trust, you will sometimes see a conservatorship of the person. And again, we cover this in other videos. And then powers of attorney. So a power of attorney is a document that I can sign and I appoint somebody my agent. So that's agency authority, slightly different than fiduciary authority, which we talk about with a trust. But a durable power of attorney means I sign a document, someone else can act on my behalf. Now, maybe that only springs to life when I become incapacitated, right? But certainly when I die, that power of attorney dies with me. So it's really important to understand when it comes to trust administration, if a person is incapacitated, so if they're living, right, they're alive, but incapacitated, if you're a successor trustee of a living trust, you may be doing trust administration. You may also be using the durable power of attorney. So that power of attorney handles things like IRAs, annuities, 401ks, filing income tax returns. So this is where it starts getting a little confusing. We're talking about trust administration, but if somebody is still alive, you may be using both the durable power of attorney and the living trust for different purposes. So the living trust, it covers assets that are in the living trust itself. So what is a trust administration lawyer or attorney? What are we talking about here? Why are we talking about lawyers right out of the gate? Because when a human seeks advice from another human, right, the person who's giving that advice is a lawyer. So that's the person doing the lawyering. Now that term lawyer means dispensing of legal advice. When it's time to go to court, that's when the lawyer's role sort of morphs into that of an attorney or an advocate. So the lawyer is dispensing legal advice and the attorney is representing a person in court. So this is really important. A lot of times trustees get into trouble because they don't get sufficient legal advice. So if a trustee needs advice about the trust itself, you go to a lawyer. What do I need to do? If you might need to go to court to maybe modify the trust terms, then that becomes more of an attorney role. But there's a consultative role, right? Primarily what we're talking about here is this consultation, this lawyering role where the person that you're talking to and dispensing legal advice is outside of court. That makes sense. You want to stay out of probate court. Nobody wants to go to probate court to begin with. So the idea is the successor trustee reaches out to the legal counsel, and you really should get a lawyer who's trained. Now, I'm a certified specialist in estate planning, trust, and probate law. This is a very technical, very esoteric, complex area of law. This is not, general practitioners don't do trust administration I don't see them doing it. Even attorneys that do a lot of estate planning, many times they're not trained in trust administration. And the reason is trust administration, not only do you have to follow the terms of the trust, you have to follow statutes. Well, kind of easy because the statutes are written. You have to follow case law. That can be a little trickier because that changes from time to time. You also have to follow doctrine. Now, doctrine is this weird, nefarious concept saying, well, that's just the way we do it. It's a doctrine. So there's not really a specific case or a statute, but this is how it's done. The problem is if you're a trustee, if all you're looking at is the trust document itself, you don't know what the statutes say. You don't know what the case law is, and you don't know what the doctrine is. So you may have to do a whole bunch of things as trustee that aren't clearly stated in the trust itself. So this is very important. The trust itself is an incomplete picture of all of the duties that a trustee has in administering a trust. That's why it's important to consult with a lawyer, because if there's a huge a range of all the things you can do, you don't have to do all those in a trust administration. You only have to do those activities and those tasks that are specifically relevant in the particular case. So I think this is an area where you really don't want to do it yourself. I know in our firm, many people reach out to us for a consultation to find out, do I even need a lawyer? If mom died and you're the sole beneficiary and she had $5,000 in the bank, there's not a lot of there, right? There's just not a lot to do. But, certainly there are other cases where there's significantly more to do. So I would say lack of knowledge of all the things that need to be done is probably one of the biggest traps that I think trustees can fall into. And it can be pretty consequential, and we'll talk about that. So again, trustees work with a specialized law firm like Cunningham Legal to administer the trust because we've got the experience and the resources necessary to adequately advise the trustee. This is very important, shielding the trustee from personal liability. Something that you need to know, under California law, a trustee is 100% personally liable for all the things the trustee does and all the things the trustee doesn't do that they should have done, right? There might be a case law or a statute out there that says, well, the trustee should have done this. But if you don't know, then you got no one to blame, right? You don't have an attorney to blame for giving you bad advice. But the attorney is personally liable for all actions, and knowledge of how to properly execute the wishes of the people who created the document, as well as the trust documents themselves, how to do that and sort of the how behind it. That is really where an experienced lawyer comes in, because we can say, well, even though it may look like you want to do this thing first, you might want to make that number 3 and do these 2 other things before you do that, because that minimizes your liability as a trustee. Another thing is the attorney may need to represent the trustee in probate court to protect people, right, or trust property, meaning the trustee himself or herself, or trust property. So sometimes a trust may be ambiguous, or there may be conflicting terms in a trust, and the trustee says, gee, if I do A, then B is going to be mad, and if I do B, then A is going to be mad, so let's go to court. That's where the trustee hires an attorney to go to court. Now, in California, we don't have a distinction between the licensing, but that's when the trustee would hire someone to go to court and represent the trustee. If the trustee says, look, there's a problem with the trust and I don't want to assume that liability as trustee, so we'll go to court and have the court order me to do it, right? That's a substituted judgment petition. So again, we have the trust itself, statutes, case law, and doctrine. And those are all all have to be followed, right? The trustee has to follow all of those things. So what is the number one reason why trustees should get a lawyer or attorney? And we've said this. The number one reason is 100% personal liability for everything that goes wrong. So remember, the beneficiary is like this little baby. If the baby starts crying and doesn't like what the trustee did, that trustee has duties. That baby can be a jerk, and many times be a jerk and do a lot of stuff that really annoys the trustee. And there's really nothing the trustee can do about it, right? The trustee still has to be the adult in the room, still has to follow the terms of the trust, even if the baby or the beneficiary in this case is going off the rails and being really annoying. So trustees, 100% personal liability. And again, the personal liability is found in the trust. A trustee has a duty to follow the terms of the trust, even if the trustee doesn't like the terms of the trust, okay? This actually happens a lot. The trustee says, this is crazy, right? This doesn't make sense. Well, it's this is the way the trust is written, you're going to have to do that. So that's something that maybe is a little counterintuitive for people. The probate code is published. It's in California. These are all the laws that the legislature passes that govern trusts and estates. A lot of what the trustee must do is not stated in the trust itself. And it's not because the lawyers have written it defectively or something. It's just how the system works. Now, when do the rules apply? This is actually kind of an interesting question that I think a lot of attorneys kind of look at themselves sometimes and go, gee, well, what body of law applies? As a general rule, when a revocable trust becomes irrevocable, right? When a revocable trust becomes irrevocable, the person who created the trust dies. It's becoming irrevocable. So your living trust likely has a provision in there that says, once the person who creates this trust dies, then this trust is irrevocable. Typically, the law that is in place at the time the trust becomes irrevocable is the law that's applicable. And then, of course, that law can change going forward. So if you have a trust written in the 80s that's still revocable, but then die in 2024, a lot of times the laws that apply to irrevocable trusts or trusts that became irrevocable in 2024, that's what we're looking at. We're not looking at the law from the 80s. So incapacity. This is, I think, a tougher, I would say this is probably one where people say, gee, well, mom, she can't serve as trustee anymore. She's got Alzheimer's, and we have successfully removed her as trustee. We got a note from the doctor, and we went to the lawyer, and or maybe they did it on their own, and they removed mom as trustee, and we took that to the banks. That is more nuanced and more complex, believe it or not, than if mom dies. So there's a large body of case law that has become statute, and this has become statute in the last year and a half or so, that covers this exact situation. What must the trustee do, right? And there are a lot of things a trustee has to do. If somebody becomes incapacitated, if that trust becomes irrevocable by operation of law. So irrevocable because of death, irrevocable by operation of law, meaning the person who holds the power to amend the trust becomes incapacitated. So even though the trust says it's revocable, it may be deemed irrevocable. And the reason I'm mentioning this is not to confuse you, but this is a very nuanced area of the law. And it's important because if you're the trustee, you have 100% personal liability. Think about that. If you screw up, somebody can hold you accountable, and you got to dig into your own pockets and make that person whole. So it's a really big deal. These rules, again, they're arcane, cryptic, counterintuitive. And the tip here is to seek out competent, savvy legal advice. Absolutely not a do-it-yourself project. Again, duties and liabilities. If a stock goes down in value, the trustee is personally liable. So if you bought a stock and it went down as trustee, or you hold a stock and it goes down from the date of death to the date of distribution, that trustee is potentially personally liable for each stock that goes down, and you don't get an offset if the stock goes up. Now, if you have an investment policy statement or investment policy memorandum, this is one thing that can shield the trustee from personal liability. So guess what? When we have a client come in, we're going to talk about this. You have this stock portfolio, or, you've got this residential rental portfolio. And in some markets in the United States, as we do this webinar, some of those prices are coming down. So it's something really to be mindful of. Reason number 2 is for hiring an attorney is the tax reduction strategies, because there are some exemptions and some credits that are available, and there are time periods on these. So what I'm talking about here is if a person passes away and they are survived by a spouse in the United States, that spouse can file for a Form 706, which is the federal estate tax return, and pick up the deceased spouse's unused exemption. What does that mean? Right now, today in 2024, each person in the United States can leave $13,610,000 free of tax. So if I die, my wife can file a Form 706, and she can effectively inherit the ability to leave $13,610,000 tax-free when she dies. And she adds that on top of hers. Now, here's why this is really important. In 2026, that $13 million number is going to get cut in half, probably be somewhere around $7 million. So if you've had a spouse pass away and you have an estate that has a remote possibility of being greater than $7 million, you absolutely want to look at filing for portability. So this is one of the things. There's a time limit on it, and a lot of people miss the boat on this. They don't really put it together. They're not really thinking about it in this way, because also the trust doesn't even mention it in many situations. So again, something where you're going to want to go with a savvy expert lawyer. Their assets left to a surviving spouse have an unlimited marital deduction, provided that that surviving spouse is a U.S. citizen, meaning, a person could be a billionaire and leave it to their spouse, and there's no tax, there's no death tax, because there's an unlimited marital deduction if the trust or if the estate plan's crafted properly. Sometimes these estate plans are written in a way where you lose that unlimited marital deduction. So if you're a high net worth person, you're going to want to make sure and have that trust have someone take a look at that trust, because the way trusts were written many, many years ago, and I would say, 25, 30 years ago, a lot of times people just, 25, 30 years ago, for those of you who are younger, there wasn't as much money in the world as there is now. There's a lot more money in the world now. I don't know what's going on. Kind of reminds me of my grandfather. He said when the Depression hit, all the money just disappeared. I was like, well, what are you talking about? He said, it just went away. It just disappeared. Well, maybe this is kind of the opposite, right? So meaning, when we did estate plans 25 or 30 years ago, we might have assumed that a person wouldn't have an estate greater than $1 million, because $1 million was a lot back then. Well, sometimes the way these estates are written is they can trigger a death tax on the death of the first spouse, right? And you want to make sure and pay attention to that, because if you have an estate plan that's a little older, you would want to have that reviewed. And that's something we could certainly, if you don't have a lawyer, that's something we can help you with. Portability election is what we talked about, which is the surviving spouse picking up the deceased spouse's coupon amount. So everyone, has a coupon where you can leave 13.6 million. And effectively I can leave that to my wife, so she could double up on that and leave 26 million. So determine if the estate is, or it needs to go to probate. Are you going to have to go to probate? What are some indicators that you're going to have to go to probate when there is not a fully funded living trust? So what I mean by that, trust is bucket, right? It's like a little bucket with the handle. You put your house, your stocks, your bonds, your mutual funds into the bucket. The trustee holds on to the handle, and when that trustee stops being trustee, passes to the next trustee. If all your stuff is not in the trust, and it should be in the trust, it's like, Houston, we've got a problem. You may need to go to probate court for that, and it is not pretty, okay? So please pay attention to this. If you've had a trust for a long time and you're not sure, that's something where, whether you call us or some other lawyer, that's one thing that estate planning attorneys do, is they review the documents, they review your stuff. And I will tell you, when we meet with clients, the vast majority of the time, something is not in the trust that should be, that would otherwise require probate. So it's good just to pay attention to that. If there's only a will and no living trust, so if there's only a will, something to understand, a will is a document. It's not a legally enforceable document until that will is admitted into probate court. Probate is Latin for probare, meaning to prove, meaning the court acknowledges and admits to probate, this is Johnny's last will and testament. Without a court order, if assets are over 184,500, without a court order, you're not going to be able to do anything. Okay, so you're going to need that court order. Probate is the only way to sell, dispose of, or otherwise transfer a decedent's property, a person who's died, to the people entitled to it. That's it. Everything passes through probate. So if the kids want to sell mom's house, but she's dead, mom can't sign the deed. Okay, this is kind of basic Captain Obvious stuff. So the court appoints someone on mom's behalf, on behalf of the estate, to sign that deed and close escrow. And then the money goes into probate, and the beneficiaries have to wait until that final order. There are 10 exceptions to probate. We've been talking about a living trust. Joint tenancy, I would say, is a very dangerous and can be a rather crude tool to avoid probate. Joint tenancy means I take a property as joint tenants with Bob, then I die. Bob gets the property. So we've avoided probate in my estate, but my wife's not going to be happy. She's going to be like, hey, Bob, I want half of that property. So joint tenancy, not going to work. Certainly when Bob dies, it's going to be a probate asset. There are some use cases for joint tenancy in real estate transactions to preserve Prop 13. So if you're watching this and we might have recommended joint tenancy, we're doing it for other reasons other than probate or these other reasons. A lot of times it's to preserve Prop 13. Community property has and there's an asterisk here. It has an abbreviated probate petition or probate process. So if I die with an asset solely in my name, or if I die with an asset in the name of my wife, so if it says Jim and Lori and that's it on the deed, then she may have to go to court to get the full control of the property and title to the property, but it's a single hearing. It's not a 2-year process. Community property with right of survivorship It means that when the one spouse dies, the survivor takes the property without going through court like you would with community property. And that's a fairly recent development under California law, as in like the last 15 years or 20 years. So that's recent in state context. Revocable transfer on death deed. This is where you say, when I die, Bob gets the property. The problem is that's public. The problem is if Bob goes through bankruptcy, right? The bankruptcy court can order me not to change the deed. It's a matter of public law. And there's Medi-Cal reimbursement. So we don't see this a whole lot. A lot of people were kind of saying, great, this will make things so much easier. In the real world, people just really aren't using it. Spousal property petition is a single petition that a spouse brings to either get separate property that flows to the spouse or community property. And that's the procedure you use if property is titled as community property. The Hegstead or Uxted petition. So if you're kind of landed here because you Googled Hegstead or Uxted and you want to know what the heck's that? A Hegstead petition says that if the living trust had a piece of property in it and I refinanced the property and took it out, right? But I never put it back in my trust. Hegstead says you can go to court with a single hearing and have that property come back into the trust. So Hegstead is where the property was in the trust. Now it's out of the trust, then I die. Uxted, and by the way, these are great Scandinavian names. Totally unrelated. These are actually real names from real cases. Uxted stands for the proposition that that property never went into the trust, but I signed an assignment or some type of document acknowledging that I wanted my property in the trust. So a little bit of nuance there, but those are court petitions where you can avoid a 2-year probate process and only have a 6-week, 8-week, 12-week probate process, a single hearing. And then things that pass by contract, beneficiary designation, PODs payable on death, TODs transfer on death, affidavit of real property of small value. So if you have an interest in real property that's less than $61,500, that passes by affidavit. And then there's a petition to determine succession of real property. So this is if the property is worth a little bit more, but not more than $184,500. Then there's a petition that transfers that property. So I would say these are probate light. So a lot of these in here are kind of one and done probate hearings. They're not the 2-year big formal probate process. So a funded living trust makes everyone's life easier. I wrote the book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer, in its 2nd edition. This is the high level stuff. This kind of goes through concepts. We talk about asset protection for beneficiaries. We talk to a lot of people. They say, I do not want my future ex-sons-in-law or future ex-daughters-in-law getting anything. I want it to go to my kids. Great. Well, you can do that, right? A lot of lawyers that do estate planning don't even talk to their clients about this stuff, but it's important for our clients. So we talk to them about it. So that's available at CunninghamLegal.com. And I'd encourage you to take a look at that. Next step, gather the appropriate documents and assets. So you determine, okay, there's a trust. We don't have to go through probate court. Do we have to go through probate court? We don't know, because we need to get the deeds. We need to make sure and check the titles of all the bank accounts. So what are the documents you need to find? Well, the estate plan is an overarching term. Estate plan is like dinner, right? It's a term dinner. Trust is steak, will is mashed potatoes. Okay. So the estate plan is everything, and the trust is a very specific document. So a living trust can be amended. It can be restated. So when we say the trust, we're talking about the trust and all amendments or restatements. So the client might have done a trust in 1995 and amended it in 2005, and in 2015 did a complete restatement. A restatement of trust is a big amendment that amends every single word of the trust. So it takes away everything that happened before, right? And is a single document. For those people in our firm who like complexity and like billing on matters, when a client comes in, they have a trust with 10 amendments. Some people love those because it takes a really long time to figure out what the trust says. So let me say this another way. If you want to minimize legal expenses and hassles and confusion, don't have a trust with 10 amendments. Now, maybe 1 or 2, okay. The problem is a trust with 2 amendments, you kind of have to read backwards. You have to read the Second Amendment, then the First Amendment, then the trust, and you kind of have to reconcile all those terms. So a little bit complicated. A lot of attorneys won't even amend a trust. They will always do a restatement for clarity purposes. The other concern about an amendment is that amendment, if you have a trust and 2 amendments, and somebody finds that Second Amendment that they don't like, maybe it just sprouts legs and walks away. So there's a security aspect to it. So these are just kind of the nuances and the ins and outs. But the trust as amended does constitute the trust that we're talking about. A will is even if you have a living trust, you have a will that typically leaves everything to the living trust. So if you have some assets outside of the living trust that should have been in the trust or should be in the trust, that will leaves everything to the trust. And then an asset list. You're going to need to get together what are all the assets that the person had. Now, as trustee, your charge is to list all the trust assets. But if a person has an IRA, an individual retirement account that goes to a beneficiary, the trustee really has no authority over that. But the trustee oftentimes is the executor, and the executor is the one who's responsible for the taxes. So it's really important if you have a taxable estate, you're going to need to know all this information, because those IRAs and life insurance and annuities that pass outside of the trust often are included in a deceased person's gross estate. Gross estate meaning all their assets. Big, right? German, big. All their assets. Gross estate meaning everything that's in the trust, plus things that pass by beneficiary designation like IRA, life insurance, annuity. All of those are included in the person's estate. And that's when we start looking at, is it 13.6 million or not? So it's important to understand those. Death certificates, broadly speaking, sometimes people make the mistake of getting one death certificate. We typically recommend that clients get 10. I mean, you might be 20, depending on how many pieces of property you have. A lot of times you have to submit these documents to public agencies or governmental agencies. You end up getting them back. But if you have 10 pieces of property and you need to do 10 affidavits of death, you might need 10 death certificates to do that. Now, you will get those original documents back, but it may be a while. So on the death certificate, that's something you'll want to ping the lawyer pretty early on and ask, in my case, how many death certificates should I get? It's easier to get them all at once, like with the funeral home, than it is to get them later. Property deeds. So in California, in order to the best way to transfer real property in California is you sign a deed, it's acknowledged before a notary public, and it's recorded. Now, recordation in California is not required, although most deeds are recorded. So what we'll do as lawyers is when somebody passes away, we'll get the last deed on each of the properties. But it's important to, if you have deeds, really keep those, because sometimes people have property from a really long time ago. If you bought a property 40 years ago, that isn't necessarily going to be in a searchable index where we can readily pick it up. So getting those deeds together, I think helps the attorney, helps us, we might be missing something, right? It might not come up on a property profile if it's an older property. So getting those deeds is important. It's not that's the ownership. So you see these Old West movies where they're playing poker and someone lays a deed down and someone puts down some gold coins and the person who gets the deed gets the property. It doesn't work like that, right? So this is recorded at the recorder's office. But again, those older deeds, you're going to want to hold on to those. Tax returns, really, really important. This would be like income tax returns, certainly the 1040. If the person has filed any gift tax returns, 709, very important, because those are all sort of tracked during lifetime. And it's my understanding that the IRS building that housed all of their gift tax return records either burned down or collapsed or something. So the IRS doesn't have these gift tax returns that people have filed. So you really need to hold on to those, because they may have a record that it was filed, but they don't have the actual return itself. And then funeral instructions. You can just give instructions on I want to be buried with I want vanilla cake with a strawberry filling and white frosting and balloons at my funeral. You get really specific. And you can give a list of instructions that people have to carry out after you pass away. And you can also prepay for all of that. So you can prepay your funeral, which a lot of our clients do. Gives you peace of mind, and it's just one less thing for people to do when it comes time after you passed away. So it's kind of a nice thing to do for people that you care about. Of course, if you don't like them, then maybe just don't give them any instruction. All the assets, real property. So this is real estate. Retirement accounts, very important. Again, the retirement accounts, realistically, the trustee is going to be the point person on this. And so if, the trustee is one of 3 kids, mom and dad die, and there's an IRA that's distributed to 3 kids, many times the other 2 kids are looking at the one kid who's the trustee. It's like, okay, well, what's going on with the retirement account? So I think de facto, you'll kind of be involved in facilitating that, but not necessarily legal authority as trustee, unless, of course, that retirement account leaves it to the living trust. So different. Bank accounts, health savings account is another one. Cash, be really careful with cash. I would say probably the worst thing you can do as a trustee is to withdraw cash from an ATM. Any judge is going to look at that and go, "What are you doing?" Like, that's nuts. So I would avoid that one. But cash, if someone's got cash in the house, you definitely want to account for that. Personal property, safe deposit box, stock and bond certificates, super important. Do not lose those. If you lose a stock certificate, to get a new one costs 3% of the value of the stock. Okay. We had a case where a beneficiary, well, a family member, I should say, was withholding $1 million stock certificate. And we had to tell them, look, if you don't give this to us, we're going to sue you for the $30,000 that it's going to cost us to get a new share certificate. So very important to hold on to those. We really don't see this a whole lot anymore. When I started practicing 30 years ago, it was quite common. Most people have those in what's called a street account. So if you go to a brokerage firm, they're typically holding those onto you. Limited liability company shares. This can be tricky as a successor trustee. So if you own an interest in a limited liability company, there may be buy-sell agreements, and this is like any closely held entity like an LLC, corporation, or partnership. Just because the person died doesn't mean that they're going to be liquidated out of their portion of that holding. There may be provisions in there that allow the entity to buy the shares on certain terms from the estate or the trust. And there may be other provisions where other people can buy this. So that's something where you're going to need to pay attention, not only to the share certificate itself, but you might have to dig a little bit deeper and look at the operating agreement or the shareholder agreement. Life insurance is typically payable to directly to a beneficiary. Sometimes it's in an irrevocable life insurance trust, and we'll be covering that in other webinars. Annuities and CDs. CD is a certificate of deposit, right? It's typically has a person's name on it. If you have a CD, you're probably going to want to have that in your trust. Annuity typically goes to a beneficiary. Timeshares, I would check with your beneficiaries if they want those timeshares. A lot of people say, I don't want the timeshare. So there are some strategies we have to make it so those don't go to the next generation. Let me just put it mildly. Cryptocurrency, we've done a webinar on this whole separate topic. If you have, it just depends on how you hold the currency. Is it in a separate wallet? Is there a hard pass piece of equipment, hardware? A lot of different ways you can go on this, but I will tell you what we do find is people who have passed away with cryptocurrency, that can be pretty problematic. So you want to have that nailed down, and you typically go through, however you're holding that cryptocurrency, there's going to be a process in there for somebody to be able to handle that. Assets in other countries, certainly if you have real property or real estate in other countries, you'll want to deal with the appropriate legal professional in that country. That's very important. And then other assets in general. A lot of countries do not really do trusts, for lack of a better term. So a trust won't work in a lot of these other countries. Some it will. Vehicles, unless they're a really collectible vehicle, most people don't have a vehicle when they pass away. Those have kind of been given away or they stop driving. And many times those pass in California outside of probate by statute. Collectibles is a whole nother topic. We covered that in another webinar, but these are all the assets you're going to need to track down. Review the documents. So what are we talking here? As trustee, you've got to read, I think you need to read every document in the estate plan very carefully. You need to know what you're getting into. Now, do you have to understand it? There's a lot of stuff in there that's kind of dense. Maybe it's what we call boilerplate. Boilerplate is not a bad word. Boilerplate are these well-crafted, well-established, standardized terms and paragraphs that go into well-written trusts, okay? It's important to have those in there because you don't want to get creative on something where everyone says, why did you get creative on this? This is a completely standardized provision. So I think you need to understand that very carefully. It helps to have the lawyer by your side advising you, quite frankly. Are there special instructions regarding the funeral, cremation, or burial? This is going to happen typically very close to death. Is they're going to want to know how do you want this person's remains to be disposed of? And what about the personal effects? Who gets the personal stuff? What if your jerk brother has his stuff in your mom's house and your mom passes away? Is that your mom's stuff? Is that your brother's stuff? Well, it's your brother's stuff because it's not your mom's. So you want to be careful with that. And that's the deceit. Who gets, grandma's china? who gets these things. There's a company called FairSplit that develops software for this to split up personal property items. So this can be a source of conflict. And then who gets the specific bequests? So, or are there any specific bequests? Do the grandkids each get $10,000 or something? You got to be mindful of that. And then what is in the residuary? So there's a residuary trust or residuary gift, and the residue says, after doing all these things, everything's split 3 ways between my children. That would be the residue. And if somebody wants a house and other people want cash, you got to make sure the trust allows a non-pro rata distribution. If somebody wants to buy somebody out, if one of those kids wants to buy out the other 2 kids from the house, we have a whole nother webinar on that. You have to do that in a very specific way in order to preserve your Prop 13 protection, because you do have some limited protection still with the family home. I would say without a lawyer, it's hard to miss this stuff, and doing this on your own, not a DIY. Again, if it's entirely you're the sole heir and your mom had $5,000 or $10,000 in the bank, do you need a lawyer? I don't know. I'm going to say as a lawyer, yeah, you need a lawyer, but realistically, probably not. But if you got a jerk brother and a bunch of assets, you're 100% liable for everything. And so it can give you peace of mind to hire a lawyer. And this is very important. The lawyer guides the trustee in properly administering the trust and distributing the assets properly and quickly. If the trustee says, you know what, I want some advice, but I just want this to be between the 2 of us. Like, I've got this jerk brother. I want to know if I can do something to maybe, I don't know, do something that maybe the trust doesn't say, but I was reading about this law and there might be some wiggle room here. It's very important to understand that if you're the trustee and you use trust funds to pay the lawyer, the attorney-client privilege travels with the office of trustee. What do I mean by that? So if you're a trustee and you got a jerk brother and maybe the jerk brother's trustee after you, and you stop being trustee, and if there's something you don't want your brother to know about, you have to pay the attorney with your own funds and hire a separate lawyer. So this is really, really important. The attorney-client privilege passes with the office of trustee, but if you want some separate advice, go to a different lawyer and use your own funds. And people have been stung on that one. Notify beneficiaries. So really common question. What do we have to do in terms of notifying the beneficiaries? When a trust becomes irrevocable because of death, under Probate Code Section 16061.7, the trustee must notify the beneficiaries within 60 days of death that someone's passed away and here's a copy of the trust. You can give them the copy of the trust. You don't have to give them the copy of the trust, but if they ask for a copy of the trust, you have to provide it. Many times we just send out a copy of the trust, and they have 4 months to challenge the trust. So you send out this notice, they got 4 months to challenge it. But if they wait until, a day before the statute's that 4 months is set to run, and they say, well, give me a copy of the trust if you haven't sent it to them, then they have another 60 days. There's a rather new statute that says if a person has become incapacitated and they've created this trust, like I create a trust, I become incapacitated, and my son is trustee, my son may have a duty to notify his siblings and give them a copy of the trust. So it's a little dicey, a lot of rules in there. No, by the way, none of this is in the trust, okay? And if you don't do this as trustee, you are liable for damages. So very important to understand that. Determine date of death values. So broadly speaking, assets in a living trust get a full adjusted cost basis. So you're going to want to contact the institutions where the decedent's assets are located. And here's the rub. A lot of times people don't know what they don't know. And many times people will come into our office and we'll ask them, what is the cost basis of your Apple stock? The cost basis is what you paid for it. When we look at the statement, sometimes that cost basis information is missing. It's just blank. It's because a financial advisor didn't take the time to put the cost basis information in. So it's very important that Apple stock gets an adjusted cost basis. So if I have a bunch of Apple stock and then I die, it's included in my living trust, that gets an adjusted cost basis. So as trustee, you're going to want to reflect that new cost basis. So right, whatever the stock's trading for on that day, it's the mean of the high and the low of that day, then that's the new basis for the stock. And then it saves the people who inherit the stock a lot of capital gains tax. Real estate should be, you should get a date of death value on real estate. And some people say, well, can I get a BPO, a broker's professional opinion, or do I have to do a full appraisal? When you pass away, real estate gets an adjusted cost basis. By the way, if you're a surviving spouse and this is community property, you also get an adjusted cost basis. So this is really important. I'm a fan of getting an appraisal. And the reason is if there's an IRS audit, if anything comes up, it's really hard for the IRS to argue an appraisal. And this audit comes up 2 or 3 years, by the way, after the appraisal's done in many cases. If you have this broker's professional opinion, it's just an opinion. It's not a valuation. So, if it's residential real estate, what are you paying? $500 for an appraisal, something like that? Not that big of a deal when you look at what you're saving. So I wouldn't step over a $20 bill to pick up a nickel, if you know what I mean. Personal effects, jewelry, artwork, collectibles, closely held businesses all have to be valued, date of death values, and retirement accounts. So remember, you got to figure out what is the value as of the date of death of this particular retirement account, because it's all included in the estate, right? And so if it goes up over $13 million, then you're going to have some death tax and very complicated stuff. Pay taxes. Okay. Pay taxes, probably the least favorite topic is paying the tax. Planning to avoid tax is super fun, but paying it kind of stinks. Trustees trustee is also many times the executor. It's the executor who files the final tax returns. And for simplicity's sake, we just say trustee. But if the trust earns any income after death, that's a separate tax return. So there's a 1040, your final income tax return. A 1041 is for any income that the trust earns after death, if there are trust assets. And I wouldn't do these on your own. This is qualified CPA. This is attorney territory. Really, this is something where you're going to want to get help. And this is on the taxes. Now, accounting. By the way, there's a 706, which is death taxes if it's taxable estate. And I think we'll cover that in a couple of slides. Trustee accounting, very important. Under the Probate Code section 16063A, all accountings. Now, there is a duty to account. This is non-waivable in a trust. Beneficiaries can waive an accounting. I think in many times it's not a good idea. And I'll tell you why. Because, what I've seen in the past is mom and dad pass away and maybe there's $3 million and one kid gets $1 million house and the other two kids each get $1 million. Then 5 years later, that one kid who's bought the house maybe fixes it up and that house sells for $2.5 million. And the kids go, wait a minute, we only got $1 million and you got $2.5 million. It's like, no. I had this house. I had it for 5 years. It went up and I put a bunch of money into it. So what a trust accounting helps with is it establishes all of that, right? The trust accounting gives asset information, breaks it all down so that you have a complete record when these checks were written. So mom died and a year later the checks are written or whatever it is, everything was fair. It all went a third. So you don't have people second guessing you years and years later. And if you're the trustee, remember, you're personally liable for that. And that statute of limitations does not start accruing until you render an accounting. So it's kind of unlimited, right? So if you never account as a if you never do an accounting as a trustee, this clock never starts running. And it's a lengthy statute of limitations to begin with. So receipts and disbursements of principal and income, statement of assets and liabilities, got to say the trustee compensation, agents hired by the attorney, and language that the beneficiaries can go to court to get a court-approved accounting. And 3 years is the statute of limitations. Think about that. So a beneficiary has 3 years to hold a trustee accountable for something they shouldn't have done or something they did that they didn't do that they should have done. Hold, administer, and distribute the assets. So after the accounting, after all this is done, the trustee holds, administers, and distributes the assets. Now, if the estate plan says when mom passes away, pay all the bills, sell everything, distribute all the assets, write everyone checks, that's a distribution. Holding and administering might be, well, if someone's under the age of 25, we're going to hold this property in trust. So that would be an example of holding and administering. Or if somebody says, little Sally, she's little, she's 60, she's still financially irresponsible, and I don't want her to blow this $1 million inheritance, then her brother Bob may hold, right, for Sally, for his sister, may hold this inheritance kind of for her life and maybe dole it out to her. That's a dole it out trust that we talk about in the book. Dole it out trust is not a legal term. It is money that is doled out to Sally because she's irresponsible. So if you're doing this, this is a long-term hold as a trustee, we really encourage you to get legal advice, at least have a lawyer available. You don't want to step in it. And the trust administration lawyer also guides the trustee in distributing assets to the proper beneficiaries as quickly as efficiently as possible. Now, here, what do I mean by proper beneficiaries? Well, sometimes people die out of order. So let's say mom dies and she's got, Sally. She's leaving some money to Sally, but Sally died before mom. Sally has 3 kids. Well, we need to determine, are those really her kids, right? Do they meet the qualification for parent to child? What if it's a step kid? Does that step kid count as a child? Well, the step kid might count as a child, might not. Depends on the facts and circumstances. So this is certainly where you'd want a lawyer involved in it. Now we're going to talk about paying taxes again, IRAs and 401ks. I want you to not get mad when you see this, okay? There are minimum distributions on IRAs and 401ks. Okay, you know that if you have a retirement account, you hit 73 and 75 in 2023. Here's the deal. When people pass away, it's a separate set of rules. So when people pass away, up to 94% of your retirement account can be paid in taxes. I do not want to be the bearer of bad news. This sounds a lot like the Beatles song, The Tax Man, right? 1 for you, 19 for me. 37% income tax, 3.8% net investment income tax, if you're in California, 3.3% state income tax, and 40% federal estate tax. That's $941,000. This is how it works. Person passes away with a large estate, let's say a $20 million estate with $1 million IRA. You're not going to take money out of that IRA because you have to pay income tax on it. You might be able to wait 10 years, just depending on the circumstances. You might not have to take any money out for 10 years. You still have to pay death tax on the full $1 million, right? That's 40% death tax. So an effective rate of over 94%. Ouch. So this is if Bob inherits $1 million IRA from a large estate. What can you do? Do a Roth conversion, right? Because that money you pay in income tax is not in your estate and you're not paying. Basically, the problem, the real problem with this, you're paying estate tax on something that will go out as income tax in the future. And that's really the troubling aspect of this. And I'm not really I hear Ed Slott talk about this. I'm not really seeing this in the news, but I don't know why. I think it just is unbelievable, frankly. So in California, working to prevent reassessment of real property under Prop 19 is a highly specialized area. Very few lawyers know this. Lots of lawyers, if you're a lawyer watching this, lots of lawyers reach out to our firm to get help on this. And remember, death is a change in ownership. So when mom dies, that's the date that the property is reassessed. It's not date of distribution. So if you've got mom passes away and the property sold 6 months later, there's going to be a supplemental reassessment that comes in maybe after you as trustee have distributed all the money. So you might get a $15,000 tax bill, right? That comes in and that has to be paid. That is unsecured, meaning it's a personal liability of the trustee. So the trustee is personally liable. If you've already distributed the assets of the estate without a sufficient reserve, you have no legal basis to get money from the beneficiaries. So very important to understand. This is why you need a lawyer calculating this. Oh, mom died, and that the assessed value is 500,000, but the market value is 3.5. Yeah, there's going to be some extra tax. We can kind of roughly calculate what that's going to be, pretty much the penny, looking at the tax bill. And then we would want to make sure and keep a reserve of that. Or, maybe one of the kids wants to take the property. How do we buy out a sibling? Again, we covered that in other webinars on our YouTube page. So very, very important to maintain those Prop 13 taxes, if at all possible. So here's an example here. We've got a $200,000 property. Look, if you keep your $200,000 assessment on a $750,000 property, your taxes are $2,600 a year. If they're reassessed, they're $82. Why wouldn't you do what you can to save, right? I don't know, it's $6,000 a year, $5,500 a year, and you might own that for 20 years, right? It's a lot of money. And remember, these go up 2% a year, so that $2,600 tax bill goes up 2% a year, but the $8,200 goes up 2% a year as well. So that's a significantly higher nominal increase, right? It's the same percent, but your taxes are going up more each year. Seek legal counsel. I would say this is the big takeaway. Look at the trust administration lawyer as the trustee's wingman in distributing assets and information to the proper beneficiaries as quickly and efficiently as possible. The lawyer's the trustee's wingman to interpret the terms of the trust, provide the beneficiaries with notices, and accountings and coordinate with the financial institutions and manage disputes. So if there's a dispute, the lawyer oftentimes can be a dispute resolver. So we are not in the business of creating conflict. We're in the business of reducing conflict, reducing hassle, reducing legal fees, reducing taxes. And that's really why we're here to help our clients. So if you're watching this on YouTube, go ahead and subscribe to our YouTube channel. Next, we have April 25th, Oil and Gas Investing, a tax mitigation strategy. If you want to pay less income tax, watch this webinar. This is a great webinar. Lots of our clients do this. Lots of our clients do solar and oil and gas. These are tax advantaged investments. So believe it or not, the government is encouraging Americans to invest in oil and gas. And I know some people have a real problem with this. They say, well, we need to get off of oil. We need to get off of oil dependence. Yes. And the government's still offering tax breaks for oil and gas. So check it out. And we still need oil. I drive a Tesla, but we still need oil, right? So we'll open it up for questions. If you're watching this on YouTube, keep watching because magically the next webinar is just going to roll and we'll see you next time.